This is the current federal tax development for the week of June the 29th, 2026. Current federal tax developments are brought to you by your state society of CPAs. Hello, Ed Zollars here, coming to you again from Phoenix, Arizona. We're going to dive into a series of judicial rulings and some administrative alerts been handed down in the past week. These developments represent some major shifts in some federal tax litigation, direction that the IRS appears to be going on the employee retention credits in the middle of all this. So we'll be seeing some of that. And we're going to talk about a release from the Office of Professional Responsibility here toward the end of the time when they're going to be called that, related to the use of artificial intelligence in tax practice. So specifically, let's take a look at what we're going to be doing this week. Um, we're going to be talking about a few things. We'll talk about some S corporation nominal ownership, and as that wicks into a innocent spouse claim, as well as the use of the abuse exception to still grant a spouse innocent spouse treatment, even if in this case she knew or had reason to know about the omitted income. We'll take a look at the ERC and how it gets involved with Section 7405 civil actions. If the IRS has refunded you tax, can they sue you for a refund? Or does this have to go down the deficiency path? That was litigated this week. We're also going to talk about a case that involves constructive dividends, the formalities of legal entities, and civil tax fraud. So interesting, all kinds of things. We also have a case on collection due process hearings, offers and compromise, and how we compute reasonable collection reasonable collection amount. All of those backgrounds. Again, as I already mentioned, the professional responsibility and responsible AI use from the OPR. And then finally, we're going to talk about another ERC case. This one coming down requiring a basically employer who was going for this credit to produce relatively rigorous proof for a partial suspension claim. And we'll talk about how the taxpayer hasn't really lost the case yet, but they also were basically told that what they'd submitted didn't come close to showing what they'd have to show in order to prove that certain government orders led to a partial shutdown of their business. You've got to connect the dots. And in many ways, the ruling in this case was they just hadn't connected the dots in their initial pleading. So let's begin with the first case this week, the first issue. This is the tax court's bench opinion in the case of Slyman versus Commissioner. It was decided on May 6, 2026. And this case looks at some interesting issues you run into with joint several liability disputes under Section 6015, the innocent spouse provision. It provides some, I think, important guidance for us in actual practice on two fronts: how to look behind corporate paperwork to defeat formal ownership listings that may exist, and how the court expanded the domestic abuse exception to overcome the fact that a spouse had constructive knowledge under 6015B. So let's take a look at the background and the procedural history of this case. For the 2016 tax year, let's say 2016 tax year, get it right, Amal and Chad Sleeman timely filed a joint return reporting a rather nominal tax liability of $610. However, the return also claimed a substantial pass-through loss of nearly $200,000 on a Schedule E that came from an S corporation, San Uvier, that was formed in early 2016 by the husband, Chad. On San Uvier's Form 1120S, the wife, Amal, was listed as a 31% owner. Chad was listed as a 49% owner. This loss generated a federal tax refund of $57,147, which the IRS now believes they shouldn't really have received. Following a long troubled marriage, the couple separated in September of 2018. So basically 2 years later. The IRS examined both the corporate and joint returns and ultimately disallowed the S corporation's loss, which led to an agreed joint assessment of $56,574 in June of 2020. 2 years later, Mrs. Sleeman filed Form 8857 requesting innocent spouse relief under IRC Section 6015. The IRS granted her partial relief under 6015B, and the Office of Appeals granted partial relief under the separate liability provisions of Section 6015C. Unsatisfied with only partial relief, Mrs. Lehman petitioned the tax court, and her ex husband intervened to actively oppose her receiving such relief. So we're now in court. The court's got to decide, should Mrs. Sleeman be able to get out of part of this liability, or as Mr. Sleeman's pushing for, hey, you know, she should be on the hook along with me. Which way are we going to go? Well, when evaluating innocent spouse terminations, Section 6015E7 mandates the tax court applies a de novo standard of review. That means the scope of the review is based on administrative records, but can be supplemented by any newly discovered or previously unavailable evidence. They're not just limited to what's in the record. And that means essentially you're virtually starting over. They can view it from the beginning. In this case, the supplemental evidence was highly consequential, which was the trial testimony of both Amal and Chad, along with Exhibit 18R in the case, a written separation document. Although the IRS argued for relief under the equitable provisions of 6015F, Judge Holmes chose to analyze the case under the statutory framework of 6015B. Under Treasury Regulation 1.6015-2A, 5 hurdles must be met. First, filing a joint return, and the fifth, timely electing relief within 2 years of collection activity, were undisputed. Those two were met. The entire battle centered on the issues of attribution, knowledge, and equity. The ex-husband argued that because of her formal 31% paper S corporation ownership on the return, a proportionate share of the tax liability was legally hers. Okay, we're in that structure. But we need to look a little bit deeper here, right? To address the attribution requirement, Judge Holmes looked beyond the formal corporate paperwork that said, hey, here's a stock certificate issued to Mrs. Sleeman. So tough luck, you're liable. The trial testimony revealed that Mr. Sleeman had formed Sanuvier with the third party with whom he was having an adulterous affair. Kind of useful. That may be part of the reason why the marriage had trouble. We'll get into that idea. But Mrs. Sleeman maintained a separate full-time career and absolutely zero involvement in the management, operations, or formation of the S Corporation. In fact, she testified credibly per the judge that her listed 31% ownership was a complete surprise. She only discovered it during the IRS audit that she supposedly owned 31% of this S Corporation. The court ruled that she had contributed no capital, no labor, no operational knowledge. That established a nominee situation. She was holding the shares on behalf of her husband, right? So Judge Holmes drew a direct analogy to Revenue Procedure 2013-34, where a spouse listed nominally on an asset can rebut the presumption of ownership of that asset. Critically, the ex-husband could not produce any operating agreement or corporate document that contained Mrs. Sleeman's signature. We could never show she signed anything. In essence, if she's so involved and she's one of the shareholders, how come she never signed for anything? That was one of the problems. Combine this with credible evidence that Mrs. Sleeman that Mr. Sleeman, I should say, had previously forged her signature, right, on the deed to the family home to transfer it to himself. Sounds like a real nice guy. That just totally destroyed his credibility. The court held the entire S Corporation understatement was attributable solely to Mr. Sleeman. They weren't going to fall for this paper saying, hey, wait, she owes 31% of the company. Court wasn't going there. The third hurdle under 6015B is the knowledge standard. Now, while Mrs. Sleeman lacked actual knowledge, she did have high-level awareness that a business existed. However, during 2016, Mr. Sleeman earned nearly $250,000 at Cisco, which made a substantial Schedule C loss seem plausible to a reasonable person. This high-level awareness made constructive knowledge a troubling issue. To resolve this, basically, the court turned to the domestic abuse exceptions under Treasury Reg 1.6015-3C2V. Under this rule, severe abuse that causes a spouse to fear retaliation overrides the normal knowledge limit. The trial and administrative records, per the judge, revealed a extreme physical and emotional abuse situation. Mr. Sleeman had thrown boiling water at Mrs. Sleeman, per the court, burning her arms, physically assaulted their minor children, hidden 20 firearms in the home that she only discovered when there was a problem in the home. Like, I believe they fell out of the ceiling, as I recall, right? and made false claims to her employer to get her fired from her job. So, nice guy, like I said. Even at trial, his abusive display was on behavior as he badgered her. Per the court, the judge said he was forced to order him to shut up during the case because he was badgering his wife, during as the case was going on. So Judge Holmes extended the abuse exception, which is technically limited to actual knowledge under 6015C, to overcome the reason to know standard under 6015B. So again, technically, this was supposed to be just see you knew but didn't. Well, this case, the judge says, well, it doesn't make sense to say if she knew about it, then his threats, the risk of him threatening her, or she could have been scared enough not to raise any questions. But if she didn't know but just should have known, you know, wouldn't he also potentially have made her afraid of even trying to find out about what was there or make more inquiries? It's like, so makes sense that you should be able to apply this, assuming that the abuse is documented, which the court ruled it was, that the abuse was there, right? Finally, the court turned to the inequality analysis under section 6015B1D, evaluating the factors from Revenue Procedure 2013-34, section 4.03, which is how the IRS is supposed to go through these equitable rules. First, the marital status favored relief because the couple was legally separated under New York law. Second, Mrs. Sleeman demonstrated financial hardship. Although her income exceeded 250% of the poverty guidelines, her actual basic monthly expenses exceeded her income because she was forced to deplete her retirement accounts and borrow from the family to cover massive legal fees from an 8-year divorce proceeding. You can tell things are going really well there. Third, the abuse excused any constructive knowledge. Fourth, Mrs. Sleeman introduced Exhibit 18R, a written separation agreement signed by her husband stating, see, he didn't have anything signed by her. She's got this signed by him. Amal, which is her, is relieved and not responsible for any or all taxes owed for 2016. I'll assume responsibility. This established a legal obligation to pay, heavily favoring relief. Now remember, the IRS is not a party to litigation. Generally, that agreement is not going to bind the IRS, but the IRS will consider that in this case when granting innocent spouse relief. The key takeaways are clear. Paper S corporation ownership is a rebuttable presumption, and severe domestic abuse can judicially overcome constructive or actual knowledge of the income in question. Again, we're going to have our nice little infographics this week. This week, the Clay versions, right? So as we wrap our analysis, let's take a look at the visual summary. And you can download them again. It'll be in the slides on the website, currentfultaxdevelopments.com, under the, basically current, weekly, or I should say, under the audio and video tax updates. Or you can just watch them. If you're watching the video, it's right here on the screen in front of you. So the left side illustrates the first major lesson, how nominee status can successfully rebut formal paper-only ownership listed on a tax return. If the spouse has no capital contribution, no labor, no operational knowledge, their listed ownership percentage is nominee ownership, and given the facts, they can basically rebut the fact that that's their income. The right side diagrams the two-step domestic abuse analysis under 6015. First, the court adopts a broad, realistic view of abuse encompassing physical, emotional, and economic control. Second, the court applies this abuse exception directly to excuse constructive knowledge or reason to know under 6015B in this case. Finally, the bottom of the graphic shows how equity ultimately overrules formalistic rules when the husband's severe abuse, the court found, has actively prevented his wife from challenging the joint tax returns. So that's the justification for this case. Next up, we're going to go to a case involving the Employee Retention Credit, or ERC. As the IRS continues its massive nationwide enforcement and compliance campaign against improper pandemic-era credits, a critical question has landed in the federal courts. What exact procedures must the IRS use to claw back erroneous refunds? Does the IRS have to issue administrative assessment under Section 6205 and meet the timeframes there? Or can they sue the taxpayer directly in federal court under Section 7405? In Plastic Film LLC versus United States, decided June 22, 2026, the United States District Court for the Southern District of Mississippi provided a definitive answer to this procedural question. while establishing some pleading standards that protect taxpayers from boilerplate government claims. The government was sloppy here. So we have that, right? So let's examine the background of this case and where it came from. The taxpayer, Plastic Film LLC, initiated this litigation on April the 1st of 2025. They filed a federal complaint against the United States and the IRS. The taxpayer asserted two primary claims. First, a refund of payroll taxes under Section 7422, and secondly, multiple violations of the Administrative Procedures Act or APA by the IRS. In January 2026, the court dismissed most of the taxpayer's claim. It dismissed the refund claims for quarter two of 2020, quarter four 2020, and quarter one 2021 because the IRS had actually issued those refunds. Okay. The APA claims were also dismissed for lack of standing, lack of a sovereign immunity waiver, and the failure to state a claim. This left only the taxpayer's refund claim for quarter three 2020 active. However, and this is one of the risks of going to court if you've received a refund. On February 3rd, the IRS, the government now, not the IRS, this is just Department, decided to file an answer and counterclaim under Section 7401 and 7405, seeking judicial recapture of those already issued refunds from quarter two and quarter four of 2020 and quarter two of 2021. Now, Plastic Film is saying, wait a minute, foul. They responded by filing a motion for judgments on the pleading under Rule 12.3, seeking to throw out the government's recapture counterclaim by claiming they had no right to move under basically 7405. In the motion for the summary judgment of the pleading, the Plastic Film raised a very creative procedural defense. In 2023, the Treasury issued final regulations under Treasury Reg 31.3111-6B and 31.3221-5B to govern the recapture of erroneous pandemic-era tax credits. The regulations state that erroneous ERC refunds shall be treated as underpayment of payroll taxes. Plastic Films argues that the word shall makes this administrative process mandatory and exclusive. Under their exclusive remedy theory, the IRS must use the administrative assessment and collection process under 6205, which has strict procedural rules and timelines. Because the IRS bypassed this and went directly to a civil lawsuit under State 405, the taxpayer argued the counterclaim must be dismissed. The government countered that Section 7405B is a long-standing independent statutory remedy. And citing the Supreme Court's landmark ruling in United States versus Wirtz, the government asserted its right to recover erroneous payments is completely independent of any specific administrative statute. Now, to resolve this dispute in procedure, the district court looked at the regulatory history and the preamble to the 2023 Treasury regulations that were published in the Federal Register. The court found the preamble explicitly states these assessment administrative collection procedures are not intended to be exclusive and therefore do not replace the existing recapture methods, but rather represent an alternative method available to the IRS. Under a plain language analysis, the court ruled that these administrative procedures are alternatives, not replacements for 7405 civil suit. The court clarified the use of the word shall in the regulation does not negate Congress's explicit, separate grant of authority for the United States to recover erroneous refunds through federal lawsuits. Consequently, the court held the United States is fully authorized to pursue recovery of erroneously issued or refunded ERC amounts through a civil action under 7405, which was a procedural victory for the government in this case, because obviously they're now going after those old, amounts that were issued. Like I say, that is a risk you're going to see you're going to see this come up in later cases too, where we're going to see, that you go to court and the IRS just files back now and comes after your refunds. So there is that danger of, poking the bear in this case. Now, it wasn't all rosy for the government, though. Even though they won their legal battle under Section 7405, it suffered a major defeat regarding the factual sufficiency, I'll get my word out there, of its pleadings. Under Federal Rule of Civil Procedure 12C, which applied the identical plausibility standards as Rules 12b-6, a pleading must contain sufficient factual matter to state a claim that is plausible on its face. We're going to run to this issue too, but for a plaintiff coming up here shortly. The court contrasted the denial in the detail in Plastic Film's original complaint with the threadbare nature of the government's counterclaim. In its complaint, Plastic Film sufficiently plead its eligibility by providing specific detail about its food and industrial divisions, which comprised more than half its business in 2019. Now, the government's suspension orders forced them to shut down. By contrast, the government's counterclaim merely asserted a boilerplate conclusatory statement that plastic film was not eligible for the ERC, didn't explain why. There were no facts explaining how the taxpayer failed to meet the eligibility requirements. And so, citing the case of Ashcroft versus Iqbal, the court ruled that threadbare recitals and conclusatory statements do not suffice. The government must plead specific facts demonstrating ineligibility to proceed. Now, the district court also addressed a statutory misclassification by the government, which mistakenly cited Section 3134C2A a provision that only governs the third quarter of 2021, which is not issued here. Remember, the whole ERC was part of the CARES Act, and then some modifications made later to the CARES Act. Only at the very end did we assert the ERC into 3134, and for most taxpayers, the only quarter that 3134 of the Internal Revenue Code governed the ERC was going to be the third quarter of 21, right? However, rather than dismissing the case outright, the court exercised its discretion under Rule 15A2 to deny Plastic Film's motion without prejudice and granted the government 14 days to file an amended counterclaim to correct the citation and plead sufficient factual detail. In essence, they're going to put that in, and if Plastic Film wants to say that one's still defective, the court will take it up again. So they'll do it. So for practitioners, Plastic Film delivers some strategic lessons. Note, the IRS, per this court, can initiate a 7405 civil suit to claw back ERC refunds, even if the normal statute of limitation for administrative assessment has expired, subject to the separate limitation window on those suits under 6532. And secondly, and most importantly, this is a useful defense we have here. If the IRS files boilerplate civil lawsuits or counterclaims against your client alleging ineligibility without pleading specific factual detailers, then their counsel can and probably should move for dismissal under Rule 12b, 6, or 12c. Right? If the IRS did it here, it's probably happening elsewhere. By the way, the flip side of that's true. We're going to see taxpayers filing similarly, very, very skeletal claims without connecting the dots. You have to do that. And if the dots aren't connected, then you can get called out on it. Okay. Now we again have our visual summary again. So we're going to take a look at this, the core balance established by the plastic film court. On the left side, we see how the government recovers funds. The court reaffirmed that civil lawsuits under 7405 are a valid, independent path for the government to recover erroneous refunds, that the 2023 administrative assessment regulations were merely an alternative, non-exclusive pathway. On the right side of this image, you're going to see the defense high pleading standards. Even though the IRS has the power to sue, they cannot simply file boilerplate, right? In essence, as the court mentions in a later case, if you were allowed to just kind of do these very vague statements, it would encourage a lot of frivolous lawsuits. You need to state a claim that, assuming that you prove all the statements in there and they're actual factual statements, you prove these facts, not just a conclusatory statement of the law, you prove these facts. If you prove those facts, it would establish a prima facie case. In a prima facie case, you've established a prima facie case that if the other side doesn't present additional evidence, you would end up winning. And that's the problem here. They did threadbare statutory recitals. They didn't cite specific gross receipts figures, concrete facts demonstrating that, the client was not subject to a qualifying government suspension order. So basically, this graphic summarizes both the bad news for the taxpayers on the left and the good news on the right. Now we're going to go on to our third issue this week, focusing on constructive dividends, corporate formalities, and the civil fraud penalty under IRC Section 6663. In closely held corporations, the line between personal and business expenses is frequently something the IRS is very interested in. When a controlling shareholder treats the corporate treasury as a personal pocketbook, and we've all had those clients that just seem to write checks on whatever checkbook they can find, the tax consequences can quickly escalate from simple deduction disallowances to 75% civil fraud penalties. Now, the tax court's recent decision in this case, He versus Commissioner, TC Memo 2026-53, serves as an instructive and somewhat sobering case study for CPAs, EAs, and tax attorneys. It underscores the absolute necessity of strict adherence to corporate formalities, the unforgiving nature of 67D's anti-Cohen rules regarding travel and entertainment substantiation, and how the IRS establishes the fraudulent intent to sustain civil fraud penalties, which is a 75% penalty. So let's look at the background of this case to get started. Take a look at the court's findings of facts. Albert S.N. He is a graduate of the U.S. Naval Academy, and he incorporated Weimana Enterprises in 1998 as a C corporation holding company. Weimana owns several subsidiaries, including Sandwich Isle Communications, Clearcom, and Hoopa's Insurance, a captive insurance company which Mr. He was serving as president of each. Mr. He routinely used personal credit cards to fund his lifestyle, right? Paid the balances personally, and then directed his assistants to obtain corporate reimbursements. The expenses were deducted by the subsidiary, repaid to Weimana, and then reimbursed to Mr. He. Weimana had a highly structured travel coordination and review process for normal employees, but Mr. He, essentially, right, didn't really quite get into this, right? We get into that. He and his family were completely exempted from going through that process. Everybody else had to do it, but not them, right? So we have that. And that's also not good. It's like, why aren't you subject to it? Are you, so you're allowed to do these things when you wouldn't allow an employee to do them? Yeah, might be said, well, maybe that's because you would treat these as personal expenses of the employee. That's like what you're kind of telegraphing here. Okay. Following an audit, a criminal referral led to Mr. He being convicted of corrupt interference with the Internal Revenue laws and 6 counts of filing false tax returns for years 2007 through 2012. He was sentenced to 46 months in prison. Following his conviction, now the civil case comes forward. The IRS issued civil notices of deficiency, inserting 75% fraud penalty against Mr. He, and Weimana C Corp. Mr. He asserted several defenses, including the statute of limitations, and argued the distributions were bona fide loans, not basically constructive dividends. Now, in deficiency determinations, the commissioner's determinations are generally presumed correct, and the taxpayer bears the burden of proof under Rule 142A. However, for unreported income, the IRS must first establish a minimum evidentiary foundation, linking the taxpayer to the income before the burden shifts back to the taxpayer. This standard is entirely different for the Section 6663 civil fraud penalty and the fraud exception of statute of limitations under Section 6501C1. Here, the commissioner bears the burden of proving fraud by clear and convincing evidence under Section 7454A. The IRS must establish 2 distinct elements for each year. First, that a tax underpayment exists, and second, that the taxpayer possesses specific intent to evade taxes known to be owing by engaging in conduct designed to conceal, mislead, or prevent collection. Crucially, under Section 6501C1, if a return is fraudulent, the tax may be assessed at any time. The statute doesn't run. Under established precedent, fraud by either spouse on a joint return suspends the statute of limitations indefinitely for both spouses. Okay. So let's take a look now at these expenses. The court did evaluate Weimana's corporate deductions. Under Section 162, a business can deduct ordinary and necessary expenses, but Section 262A strictly disallows the personal deductions. Right? If a corporation pays personal expenses for a shareholder and lacks a valid business purpose, those payments represent economic gain and are reclassified as constructive dividends to the shareholder to the extent of corporate earnings and profits. So let's look at what they tried to deduct. First, Weimana paid $6,000 to $10,000 annually for twice weekly 2-hour massage sessions for Mr. He. He claimed his chiropractor prescribed them to treat asthma. The court flatly rejected this, holding that most of the cost of maintaining health is too inherently personal to qualify as business expense under Section 162. You're probably going to need to have a valid employee reimbursement account. There are some limited executive things can be done, but the court was essentially saying here that nope, you don't meet any of those requirements in this case. Second, Weimana paid $33,523 to MIT for his daughter Adrienne's tuition, housing, and dining plan, recording them as corporate educational and travel expenses. Because she majored in architecture, which is totally unrelated to Weimana's telecom business, and the company had no educational assistant program for normal employees, The court disallowed this deduction as well. Right. Finally, Waymana purchased a 5-bedroom home in Santa Clara for $1.2 million. Mr. Heath's children lived there rent-free and sublet rooms to other individuals, keeping the rent. The court reclassified $192,000 fair market rental value of the home as constructive dividends taxable to Mr. Heath. So I had a lot of things happening here. Now, also, we had some family compensation and travel. The court applied heightened special scrutiny to Waymana's intra-family salary payments. Because the family relationship is involved in a closely held corporation, there's a total lack of arm's length bargaining in the view of the court. Waymana's deductions for salaries and retirement benefits paid to Mr. Heath's children and his wife, Wendy, were completely disallowed. The company maintains zero records of their hours work or tasks performed. That's really important to tell us what in essence are these other people doing. And we had no record of any of these, right? And his son, basically, the children were out of state college students during this time. So they were working out of state for you? Yeah, it didn't seem like. And his son testified that his mother was a stay at home mom. Under the assignment of income doctrine, these payments were treated as constructive dividends directly payable to Mr. Heath, and no deduction was allowed at the corporate level. The court also took a strict stance on travel expenses under Section 274D, the anti-Cohen provision. 274D completely overrides the Cohen estimation rule. Remember, under Cohen, generally, if we can reasonably estimate an expense, we know an expense was incurred, it can be reasonably estimated from evidence the taxpayer presents, we're allowed a deduction. But Congress has chipped away at this in various ways. 274D is the best well known, where it talks about issues related to travel, entertainment, that kind of background. Without contemporaneous logs, receipts, and detailed business purpose records, travel deductions are completely disallowed, period. Under this strict standard, the court disallowed family trips to France and Switzerland, a trip to President Obama's inauguration, a Tahiti vacation, a Disney World trip where Mr. He claimed he rode a Raytheon-sponsored ride to build rapport with Raytheon's chairman, and a $16,515 stockholders meeting at the Manui Lani Resort that lacked any contemporaneous minutes or agendas. You're holding a business meeting, keep records, guys. Yeah, it looks a lot like that. That's cover for what you're doing. A major battleground was over $1.1 million in corporate advances recorded on the general ledger as loans to shareholders. Shareholder loan accounts are a problem, and they can become a really big one in a case like this. To determine these are bona fide loans, the tax court evaluated the non-exclusive factors from the Ninth Court's decision in Welch versus Commissioner. The court emphasized that it gives far greater weight to objective indicators of debt than to self-serving statements, looking for contemporary intent to repay at the inception of the transaction. That's the most important deal. Was it clear the party receiving the funds intended to repay them when the loan was made? This is why I also tell people I don't like people, saying, "Oh no, we're going to loan the kid $100,000, but then we're going to, basically say, we're going to waive 10 grand every year, or 19 grand every year. We're a bit higher than 10 now for annual exclusion." It's like that almost demonstrate there was no intent ever to repay. So this wasn't a loan; it was a gift from day one, and it went way over the limits. So you have to kind of look at that intent to repay. The court identified fatal loan flaws. There were no promissory notes, bad, or any other formal loan agreements from 2005-2012. No collateral was provided. There were no repayment schedules. The interest only retroactively accrued after KMH LLP raised questions during the audit. Crucially, the court can contrast Mr. He's undocumented advances with a loan Sandwich Isles had made to another employee, which was, guess what? Fully secured and documented. Because Waymana did not file these same procedures for its sole shareholder. Yeah, sole shareholder is not special in this case. They've got to understand that. The entire $1.1 million balance was reclassified as taxable constructive dividends. Finally, the court examined the badges of fraud from Bradford v. Commissioner. And the court sustained 75% civil fraud penalty based on 6 badges they found existed in this case. Consistent understatement of income, inadequate records, implausible stories about what was happening, misleading information provided to the CPA, in this case preparing the return, a lack of credibility in his testimony, and Oh, yeah, criminal conviction. That's usually not good if you're trying to get out of a fraud claim. If you are convicted, you're criminally convicted on tax related charges, your civil fraud claim is probably in deep trouble. We get to the civil case. Okay. Now back to our infographic slides again. Again, as I said, these are in the slides you can download from the website. This is a training tool, shall we say, for closely held corporate clients about what they can and can't do. On the left, we see disallowed personal luxuries. It highlights, and you can tell clients this is a real world thing that happened. It highlights the disallowed family Disney trips, the MIT tuition, the annual massages, $192,000 rent-free residence in Santa Clara that was reclassified as a constructive dividend. The center illustrate what happens when a shareholder treats the corporate treasury as a personal pocketbook, leading to massive reclassifications. On the top right, we have a clear matrix of when a loan isn't a loan. It contrasts a bona fide loan with the taxpayer's actual actions, showing a total lack of notes, interest accruals, or repayment schedules. That tends to result in the reclassification when these cases go to court. And on the bottom right, we have the 6 badges of fraud, right? You know, that's the same 75% corporate fraud penalty. So, you can kind of share this with your clients who just want to, treat this as their own piggy bank. It's not good. The personal piggy bank can get you in big trouble. Let's go on to our fourth case this week. This one looks at collection due process, or CDP hearings, offers in compromise, and reasonable collection potential calculations. If you represent clients with significant tax liabilities, delinquent tax liabilities that are facing IRS collection actions, it requires a deep technical understanding of the internal guidelines and statutory boundaries governing the IRS's appeals officer. Tax court decision in Took versus Commissioner TC Memo 2026-54, handed down on June 23, 2026, provides a roadmap in this case. This case covers the precise standard of review the court applies to collection due process determinations, the strict boundaries of offer and compromise calculations, and the limits of effective tax administration, or ETA, hardship claims, and how the IRS defines necessary expenses for special needs dependents. So, again, let's get in the background of this particular case. So, the taxpayer in this case, Charlton C. Cook III, faced significant unpaid individual tax liabilities spanning 6 tax years from 2012 to 2017. Following IRS issuance of a notice of federal tax lien and a final notice of intent to levy, Mr. Took requested a collection due process hearing under sections 6320 and 6330. To resolve these liabilities, the taxpayer proposed several collection alternatives. Specifically, he proposed an offer in compromise based on doubt as to collectability and effective tax administration. He initially proposed a lump sum compromise of $175,000, which he later increased $375,000 during the administrative process. The IRS Office of Appeals rejected these proposed collection alternatives, sustaining both the federal tax lien and levy. Mr. Took, petitioned the tax court, asserting that the appeals officer had abused his discretion by rejecting his offer in compromise, refusing his, effective tax administration hardship claims, and disallowing specific monthly expenses. Okay. When a taxpayer challenges an IRS's CDP determination, the tax court reviews the appeals officer's decision under the abuse of discretion standards. Remember, we were talking about a de novo review at 6015? That's where the judge just puts himself back in the place of the person in question at the IRS, and they make an independent decision. Abuse of discretion means that the court isn't necessarily going to say it would have come to the same conclusion. It simply says that the conclusion arrived at was within reasonable discretion allowed to the IRS. Under Section 6330D, the court evaluates whether the appeals officer acted arbitrarily, capriciously, or without a sound basis in fact or law. This is a tougher hill to climb than the hill they had in the 6015 case. Crucially, the court's review is restricted. It judges the propriety determination strictly on the administrative grounds invoked by appeals. Okay. Now let's look at the OIC calculation. The appeals officer calculated Mr. Took's reasonable collection potential, or RCP, to be $499,109. That is the minimum acceptable offer. Because the taxpayer's highest offer of $375 fell significantly short of this RCP, appeals rejected the offer. Under long-standing court precedent, the commissioner does not abuse his discretion by rejecting an offer in compromise that falls short of the taxpayer's reasonable collection potential. In this case, even when the tax court performed a favorable recalculation of the reasonable collection potential by temporarily allowing some of the taxpayer's disputed monthly expenses, the resulting figure still exceeded his higher office $375,000. Therefore, per the court, the rejection of his offer in compromise was totally justified, sustained. They weren't going to overturn that, right? Okay, because his offer was below the reasonable collection potential, Mr. Took also tried to qualify for an effective tax administration or ETA compromise. An ETA compromise allows the IRS to accept a lower offer based on economic or non-economic hardship. For non-economic hardship, Took claimed his financial distress was caused by fraudulent acts, extortion, and thefts of funds by his former spouse. The court applied the strict test found in the Internal Revenue Manual, section IRM 5.8.11.3.2.14, which requires that a third-party act be the direct cause of delinquency and the taxpayer have acted prudently. The court found Took failed this test. His liabilities began to accrue in 2012 when he failed to make estimated tax payments. He acted imprudently by continuing to deposit funds in the bank account of an individual with a known addiction. It's like, you're reckless, right? That's going to be the key. Second, for economic hardship, Took requested $85,000 cash reserve to pay for future Parkinson's disease treatment. The court rejected this under Treasury Regulation 301.7122-1B3I, holding that future medical needs are highly speculative. Because Took maintained a substantial current monthly income and could fully pay basic living expenses, economic hardship was rejected by the court. Mr. Cook also challenged the rejection of his partial pay installment agreement, disputing that the disallowance of 2 monthly expenses, $1,000 for tutoring and $550 for transportation for a special need child. Now, the court applied the necessary expenses tenets under the Internal Revenue Manual 5.8.5.22.1, which defines necessary expenses as those required to provide for families' health, welfare, and production of income. The appeals officer had already allowed a major deviation from the national standards by permitting private school tuition. The court held it was entirely reasonable to disallow the additional 1,000 tutoring expenses because one of the primary arguments used to justify the private school deviation was that the school provided more specialized one-on-one learning. The transportation expense was also properly denied because the taxpayer already exceeded the standard vehicle operating costs and failed to provide a reasonable substantiation of his actual costs. Finally, under Section 6330C3C, the appeals officer balanced efficient tax collection with Took's concern that collection be non-intrusive. Because IRS had offered two different collection alternatives, which the taxpayer declined, the court granted summary judgment for the IRS in this case. So, let's go ahead with our infographic to review the key elements of the Took decision. On the left side, we'll see the limited financial hardships and OIC discussion. That visual there highlights that the IRS does not abuse its discretion by rejecting low offers that fall below the taxpayer's reasonable collection potential. It also shows that future medical reserves, such as Mr. Took's Parkinson treatment claim, are deemed speculative if current income is sufficient, and that additional child expenses like tutoring will be disallowed if they are redundant to private school deviations already allowed. On the right side, we see the standards for effective tax administration. These emphasize the strict prudent business standard required to claim third-party fraud, distinction between current economic hardship and speculative future insolvency. Now, the IRS conducted statutory balancing analysis under Section 6330C3C. So, this is a reference for cases like this about how the service approaches these issues. Okay, now we're going to go on to our fifth development. This is focusing on the Office of Professional Responsibilities discussion of professional responsibility and the responsible use of artificial intelligence in federal tax practice. Now, this is a very timely and very useful development because lots of things are happening with AI in tax right now, right? We've already seen the research services push heavily into AI systems. And I think you're going to see very shortly in the next couple of years that your tax processing software is going to have AI built in, AI features built in. So we need to be a little bit aware of what issues arise there. So on June 24th, the Office of Professional Responsibility issued Alert Issue number 2026-19. and it was titled Introductory Guidelines for Responsible AI Use in Federal Tax Practice. As we rapidly integrate generative AI into our workflows, many practitioners assume that because many of these tools are using our commercial, they're safe. Don't assume things, right? The OPR made it crystal clear the introduction of AI does not reduce, alter, or dilute your professional responsibilities under Treasury Department Circular 230. And I'll warn CPAs it doesn't dilute your responsibilities under the Statements on Standards for Tax Services number 1, and specifically under Section 1.4 for use of tools. Basically, we are responsible always for the outputs of the tools, and we're responsible for understanding that those tools are not causing issues with our requirements that we do not disclose data or use data without proper permissions when necessary. Okay. So, to understand this guidance, you got to first understand the technology, which, by the way, OPR says that's a requirement. You have to understand this stuff. You can't just treat it like, I don't know anything about what it does or how it works. That's not good enough. Traditional analytical AI, such as advanced search databases, have been common in tax offices for years. But generative AI is a complete paradigm shift. Its AI, in this case, is the use of machines in a way that mimics human cognitive skills, including judgment, perception, and prioritization. Unlike legative software, contemporary generative AI is the best example of generative AI that most people know would be ChatGPT, right? It's called generative AI. In theory, there has been a variant of AI going on for a long time, which we've called machine learning, which is somewhat different because in this case, the platform possesses discretionary autonomy. They have the ability to make discretionary decisions completely devoid of human interaction. Autonomy stems from the generative AI's use of complex pattern recognition capabilities that continually interact and evolve, allowing the program to learn basically from itself. While this technology offers huge transformative benefits, including massive cost savings, rapid data analysis, advanced risk assessment, it also creates some profound legal, regulatory, and legal hazards that you gotta actively manage. Generative AI is incredibly powerful, right? If you don't use it, you probably won't be in tax practice in a few years here. But the flip side of it is it's also incredibly dangerous. And if you don't understand and control for the dangers, well, you probably also won't be in tax practice in a few years, but for wholly different reasons. So let's talk about these issues. Now, the technical limitations of generative AI present certain operational risks, notably fabricated outputs, commonly determined called hallucinations. Right? It will do things like create cases out of thin air. Right? It also can have bias. Bias in training can exist, or it can impute bias by trying to please you, right? If you give it one really dangerous thing to give any AI is the least hint of the answer you'd prefer it come up with. If you order it to find 5 cases that prove, that the last case we just thought of, that none of that, it's all alone because there's very, very little documentation needed, there's a good chance the AI will give you 5 cases. Now, none of them will probably exist, or maybe if they do exist, they have nothing to do with loans, but it'll do it because it wants to please you. Keep that in mind, those biases. And there is, quite often, if you don't ask for it, there's a complete lack of transparency. It's not telling you how it gets to the answer. Or even in many cases, if you're actually brand new to this, it's simply going to give you the answer. And the problem is you absolutely cannot accept that. You really shouldn't from any third-party source. But I know too many people that use things like, that think, using like Quick Finder or that, they just flip there, look there, and that's what they consider tax research. No. First thing is under Reg 1.6662-4D, we are told that that's not going to give you substantial authority, whatever we do. And secondly, definitely with AI, you cannot assume that, at least when you talk about something like Quick Finder, editorial materials from BNA, Thomson Reuters, there is a professional who wrote it and who we can have at least some assumption, did some basic fact checking to make sure it's right. The AI, excuse me, the AI is simply a program, right? It's going through, it's doing it. It is very good. It is wildly good. It can uncover things very quickly that you'd miss. That's an important reason why you got to use it. But it also can hallucinate and come with the wrong things. You've got to understand why. Okay. There are severe confidentiality and data security gaps as well, right? And so, under this warning, client privacy is compromised when data generated for one client is repurposed by the program to respond to an inquiry for another client. And a lot of these will do that. They'll have memory from each session. And you're not allowed to use information from one client to assist in another. Now, where that gets, because obviously we all know things the clients have done, but AI doesn't have that kind of wall that you put in your head saying, no, I can't use this fact that I know this company is doing this when I'm working on the return for this company, right? I'm supposed to keep those facts separate and understand that. That's not necessarily what AI is going to think. It's just going to kind of, if it's building a history, it's going to incorporate that history. You got to be careful there, right? Also, if data compiled for a specific use spilled over into the algorithm and is combined with a related tax issue involving a completely different client. And these aren't theoretical risks. They have already led to some severe real world fallouts from some rather large entities that have done AI things, that have found, like, for instance, in one case, a customer relationship management database started leaking data from other clients, from other customers of the CRM, would be leaking into other people. Not really good if that's your competitor who's getting CRM, who's be able to get information that you enter into your CRM, your system based on that. Things like that can get very, very bad, right? Courts are also increasingly penalizing legal and tax professionals for fake citations in filing. Judicial sanctions have included financial penalties of several $1,000s, public censures, mandatory ethics courses and default judgment, disqualifications, and disciplinary referrals to state bars. And a really interesting case occurred in 2025 when a report prepared by Deloitte Australia was published containing what later was discovered to be generative AI generated invented quotes attributable to a judge and non-existent books, forcing the firm to agree to a partial fee refund to resolve the dispute. Be very careful when you're sending this. You don't just rip the output from AI and send it to the client without doing some very, 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 very careful review. Don't just, I was going to say, don't just accept the output. That's not going to work. Okay. Now, to address these risks, the OPR emphasizes that using generative AI does not alter your core professional duties under Circular 230. First, under Section 10.22, practitioners must exercise due diligence in preparing tax returns, documents, and representations made to both the IRS and clients. Now, while we know, due to the Ridgely versus Liu case, that there's a real question whether Circ 230 applies to tax return preparation by CPAs and attorneys, at least for CPAs, we're covered by virtually identical standards under the Statement of Standards for Tax Services. Okay. So in either account, OPR makes it clear the federal standard of due diligence cannot be delegated to an algorithmic process, and so does SSTS number 1 in section 1.4 on use of tools makes that very clear for CPAs. A human in the loop is really important. Human scrutiny, active verification of the accuracy of the facts. Did invent facts that you never told it were there? What about citations? Both that they exist and that they actually say what the AI is saying they support the position. And finally, calculations produced by AI. Calculations can be a big problem. They're not as bad as they used to be, but it's still kind of an issue. This is a large language model, not a large math model. And therefore, some basic math can be blown by the AI relatively simply. So you need to review all of these things, before any document is delivered to a client or submitted to the IRS. Under Section 10.35, you must possess the necessary competence to practice for the IRS. And this is true also of CPAs under the Code of Professional Conduct. You have to have adequate technical expertise, right, to do it. The OPR makes this very clear, and I want to make it very clear under the AICPA rules, this will be true as well, that modern competence is no longer limited to literacy with the tax law. It encompasses technological literacy as well. Practitioners must understand both the law and the technology that they are using to help them understand that law, including AI systems, operational mechanics, how do they work, their limitations, and their risk. You must have the ability to understand how AI develops its content, recognize potential for bias or errors, and evaluate whether those outputs are suitable for IRS matters. If you are not going to take the time to understand AI, you shouldn't be allowed near AI. Blunt. And nobody in your firm should be allowed near AI until they understand it. That's going to be important. Which takes us to, for firm leaders, partners, managing directors of deployment of AI, it's a compliance obligation under Circular 230, Section 1036. 1036A places an affirmative obligation on individuals with principal authority to take reasonable steps to ensure the firm has adequate compliance procedures in effect. Under 10.36B, a supervising practitioner is subject to discipline for failing to comply if through willfulness, recklessness, or gross incompetence they fail to implement procedures, fail to ensure they are followed, or fail to take prompt corrective action when a pattern of noncompliance occurs. Same is true under the AICPA rules related to either supervision of experts, use of experts, or if it's an outside, depending on what you're doing, that's not usually it. More likely, it's the supervision of your assistants. And the ABAs, which is probably the document everybody keeps referring back to, the ABAs, basically ruling on AI in law practice, which is a very, very good document. It's a rule, that ruling, I should say, it's very good at illustrating both why AI is going to have to be used and why you have responsibilities. You better darn well understand them. The standards in that statement are not that difficult or different from the standards that any EA or CPA is going to be held to, either by OPR, if it's in a practice situation for the IRS, or by your state board of accountancy, if you're in the CPA area, right? Because these generative AI platforms are often opaque, blindly relying on their projections or representations without independent verification is per se unreasonable, per the OPR under Section 1037, which means that these generative AI drafts are a starting, not an ending point. This isn't the end of your job. This is the beginning of your job to proof it, right? That's part of the need. And then on the final slide on these guidelines that we have are text, fee structures, data security, and the broader legal framework. Under Section 10.27a, practitioners cannot charge an unconscionable fee. While AI tools drastically reduce research and drafting time, billing clients for manual labor not spent or double billing for AI tasks may violate 10.27. This isn't the best worded section of this alert. The American Bar Association statement makes it much more clear. They're talking about, saying, hey, this would have taken us 5 hours. Our contract with the client is billed based on time, but because I've used AI, it only took 20 minutes, but we're still going to bill them for 5 hours. Yeah, that's frankly against your contract. It's going to be a problem. Same thing here. So again, managing practitioners must establish billing practices that fairly credit AI-driven cost reductions to the client and disclose AI activity performed. That is also somewhat important to let people know when AI has been involved, okay, in that case. Second, most critically, IRC Section 6713 and 7216 impose strict civil under 6713 and criminal under 7216 penalties for the unauthorized use or disclosure of tax information, which includes the taxpayer's name, address, or ID. Uploading sensitive taxpayer data to unsecured or public AI systems violates these laws in Circular 230 10.51A15. Also violates AICPA's Code of Conduct. right? There are very, very strict rules when you use an outside service provider. And if that outside service provider is providing has professional decision are taking place under that system, then you normally have to have the client's permission to use that system. And even if it's just, basic support, not really making the decisions, you still got to have under the AICPA rules a, reasonable, in essence, reasonable assurance, which should sound really familiar to CPAs, audit level assurance that the company, that you have an agreement that would protect those rights, that they won't violate rules that you couldn't violate. And number two, they have procedures in place to make sure that happens that are adequate. And number three, there's actually testing done to make sure, we're going to both think of it like an audit, the internal control, and then actually going out and testing transactions to make sure they're actually following the internal control. That'll be part of it is, okay? Finally, certain states like California, Colorado, Illinois, and Utah have enacted AI governance laws, and ABA Formal Opinion 512 aligns closely with these AI parameters. That's the American Bar Association's formal opinion. You can just search for that online. I'd suggest when you're thinking about drafting your own procedures and standards, that ABA document is a really, really good point about things you should consider, right? Ultimately, AI is a powerful tool you almost certainly can't ignore, but it's not a substitute for professional judgment, and you don't get off the hook by simply saying, my IT guy will take care of something. No, you have a personal, individual responsibility here. And if you think that you can assign that to the IT guy, OPR has some words for you. So does the ABA if you're an attorney, right? Nope, sorry, you have personal responsibility here. Can't do it. So if you don't want to gain that, well, maybe now it's time to retire. Just going to say, if you don't want to get the background. Okay. Well, here we have our nice little illustration of AI in tax practice. On the left side, we have our inherent risk of generative AI. You know, need to understand these risks, understand hallucinations, understand bias, how they occur, what the risks are. And as I said, to me, a key risk in bias is don't basically make it very clear to the AI the answer you want. In fact, I strongly suggest you ask it to not only tell you what it thinks the answer is, but then ask it to attack that. What's the best argument that could be raised against your position? Try to do that. And also ask it to evaluate it under the basically, the rules of substantial authority under Section 70 under the regulation 1.6662-4D. Does the position you just gave me meet the substantial authority test? Do you have that backup? And do an analysis there. I have a gem written for Gemini, and it always enforces that on the system. How will the IRS attack this? And give me a substantial authority analysis under the regulations about where your analysis ends up. It does a really good job of forcing it to go through a couple of times, justifying positions. Again, don't assume it's there. Confidentiality. Be careful of public access, especially you're going to find if you don't have a good AI policy, your staff is using AI. And they're probably using the free versions, and they're doing it without telling you. Stealth AI is a major risk factor. And why are they using it? Because it'll speed things up dramatically. And if you're just cut your time on this job, we're spending too much time on this. And that's a mantra that attorneys and CPAs give to their staff all the time, right? We took too long on this. We can't spend that much time on it. You just might as well assume you just ordered them to use AI. You may not see it that way, but I see it that way, and the staff sees it that way. So you better have rules on when AI can be used and why. I don't care if it will save more time if I ignore this little problem, like the fact that I'm using an AI that might use this data I'm uploading from the client's, brokerage statements for training its data, and it might leak out to the general public, but I'll still get my numbers way faster, which, by the way, is probably true. they would get it way faster. But we can't take that risk. We got to give this up, right? We have to have that. And understand there are real world consequences when things go wrong. Right? And then talk about the guardrails you should be setting up under Circular 230, and also the summary of the regulatory requirements on this page. Finally, another ERC case we have here. This is the sixth case. This is rigorous levels of proof required to sustain employee retention credit schemes under the partial suspension test. The most audited and litigated tax provisions in recent history is many ways ERC. Maybe they should have been litigated more. We're into that. They're kind of late to the game. We're there. Originally enacted under Section 2301 of the CARES Act and later codified as, as amended at Section 3134 of the Internal Revenue Code. We're aware of that, right? When the gross receipts test is relatively straightforward, we have little dispute on that. Disputes always come under the full or partial suspension prong under, once we're in the code, 3134C2A and the identical provisions found in the CARES Act in Section 2301. In Sundance Pools versus United States, this is from the Federal Court of Claims, case number 251291T, the United States Court of Federal Claims addressed a critical threshold interest. It clarified the exact definition of partial suspension and, most importantly, established a rigorous double-pronged causation standard under the statutory phrase due to government orders. So let's start out looking at the background and facts of this case. Okay. So the taxpayer, Sundancer Pools, Inc., is a Southern California corporation that builds residential and commercial swimming pools and spas in San Diego County, California. During the pandemic, Sundancer filed Forms 941X claiming the ERC for 6 quarters across 2020 and 2021. In essence, they went for it every quarter. Okay. The IRS initially recognized its entitlement and issued refunds for the first 4 quarters, the last 3 quarters of 2020 and the first quarter of 21. Okay. However, the IRS subsequently disallowed Sundancer's claim for quarter 2 and quarter 3 of 2021. Sundancer filed a refund lawsuit in the Court of Federal Claims seeking $660,292 for those last 2 quarters. Now, remember the other case we discussed? I think you got to start realizing the IRS is likely to do this. You have a client who got it for 4 quarters, then they were disallowed, or got it for some period, and then later ones were disallowed. You better warn them about this risk of going to court. While the IRS won't necessarily not sue you for a refund for those other quarters, it does appear the Justice Department is getting very good at just going after those refunds immediately when they sue for the later periods, right? So the government then moved for judgment on the pleadings under basically Rule 12C, contending that even if all the facts in Sundancer's complaints were true, the taxpayer failed to establish its operations were fully or partially suspended during quarter 2 or quarter 3 of 2021 due to a qualifying government order. Okay. Now, in evaluating the government's motion for judgment, Judge Elaine Kaplan, who was hearing the case, first corrected a common misconception regarding the standards of review under Rule 12C. Sundancer argued that because the government's answer and counterclaims raised factual disputes, judgments on the pleadings were blocked, it had to go to trial. Judge Kaplan clarified that the defendant's motion under 12C applies to the identical standard to a Rule 12B motion to dismiss. The court assumes all well-pled facts in the complaint are correct. A defendant's motion is granted when those facts, even if granted to be wholly true, do not entitle the claimant to a legal remedy under Iqbal. We talked about that case earlier today. Okay? In essence, and you can't just make conclusions. You need to tell me, don't say we were partially suspended. Tell me the evidence that you're going to show that shows a partial suspension. And then the judge decides if all of that's true, would that be a partial suspension? If it would be, they're going to deny the government's attempt here. If they decide it wouldn't be, they're probably going to throw it out. They're probably going to throw your pleading out, right? And secondly, Sundancer challenged the government's reliance on those 2021-20, arguing that subregulatory guidance, agency guidance, is non-binding and cannot support judgments as a matter of law. The court, now I've said this every time I say this, I'm going to keep saying this. Every court is going to tell you that notice is non-binding. Period. The court doesn't have to follow it. But This is weird because they thought Loper Bright protected them. The judge says under the Loper Bright decision and the Skidmore doctrine, notice 2021-20 constitutes a body of experience and informed judgment to which the court and litigants may properly resort for guidance. In essence, per Loper Bright, I'm allowed to look at this. It never was binding, but I'm allowed to look at this, and we're allowed to consider it. It is a litigating position of the IRS who's going to be a litigating position whether or not that notice is there. Okay, now, what is a full or partial suspension? Well, the problem is, of course, the CARES Act never defined fully or partially suspended. So the court applied its ordinary contemporaneous common meaning. Examining various definitions from dictionaries, the court concluded that a partial suspension is a temporary interruption, postponement, or cessation of more than a nominal portion of the business operations. To define nominal, the court did turn to Notice 2021-20, question and answers 17 and 18. Under question 17, closed operations comprise more than a nominal portion if they represent at least 10% of gross receipts or employee service hours. So that essentially becomes a safe harbor, right? And under Q&A 18, work-based modifications do not constitute a partial suspension unless they have more than a nominal effect on the employer's ability to find goods or services in the normal course of business. Crucially, the court held that because all businesses had to modify practices during the pandemic, a taxpayer must prove something more than simple disruption. This is a presumption out statute, meaning exclusions are construed strictly. Most importantly, lost revenue is not a metric for suspension. Reduced revenues are studied under decline in revenue test. You can't use decline in revenue unless you meet decline in revenue test, in which case then we're not going to go suspension. We're talking suspension, we're not looking decline in revenues. Congress told us the decline in revenues that they thought deserved to have assistance. Now we're going to suspension. The court next analyzed the causation standard required by the statutory phrase due to. Remember, we had those conflicting cases on due to issued the same day a couple weeks ago. Like suspension, due to is not defined in the act, creating ambiguity regarding the precise nature of the causal relationship. Judge Kaplan adopted the reasoning of Northeast Health Services versus United States, holding that due to requires a showing that a qualifying government order was both the factual and proximate cause of suspension. They're following the other Court of Claims case we talked about, Northeast Health Services, a couple of weeks back. This means the taxpayer must prove but for causation, they wouldn't have shut down but for the order, and proximate foreseeable causation, which means tie it directly. The court explicitly rejected a simple but for standard. Remember, the Eastern District Court in Washington used a simple but for standard? Again, this is the Court of Claims rejecting that, right? They said a simple but for standard, essentially, if you interpret it as merely interpreting that due to is merely but for causation would conflict with the broader statutory scheme. And second, a simple but for standard would expand the suspension prong so broadly that it would swallow the decline in gross receipts test. Under established tenets of statutory construction, an interpretation that prevents one qualification requirement to supersede an alternative requirement must be rejected. There used to have to be two separate ways in, not a way in and a second one that really is just that other way, is just a subcategory the other way in. Just what the court found that would be in this case. Therefore, the government order must be the direct, proximate, and foreseeable cause of an actual temporary struggle. And you got to connect those dots. I need the order. I need to know how it directly caused this, direct, proximate, foreseeable cause of it, right? And show it actually rose to the limits of your proper temporary stoppage. Okay. The court applied these standards to Sundance's complaint, finding 5 distinct claims deficient. First, decreases in operational efficiency from social distancing did not constitute a stoppage or suspension under the law. Period. Done. Out. Second, municipal permitting delays of up to 6 months did not cause temporary cessation of a distinct portion of the business. They didn't show. They have to tie it in. The problem in most of these cases, they never tied any of this together, nor tied it to a specific government order. Supply chain descriptions that forced companies to switch vendors did not qualify because Sundance developed workarounds to continue to operate. Under Notice 2021-20, question and answer 12, suppliers shutdowns only qualify the employer cannot obtain critical goods from any alternative source. And the court found that a reasonable way to view this. You had other sources. You might have paid more, but you had other sources, right? Fourth, severe cement and steel shortages were caused by broad macroeconomic forces, not by a specific local order they could point to, right? That's it. And fifth, although Sundancer argued in its brief that job sites were closed, the actual complaint contained no mention of job site shutdowns. So you must plead specific actual stoppages, establish factual and proximate causation, tie it to the actual orders in question, right? Match the claim's precise quarters, and ensure your complaint is completely detailed. Theirs was skeletal. Now, it read like a lot of reports I saw from certain people that were, doing a lot of ERC consulting that were conclusatory, or simply said, we had trouble getting supplies, therefore it's a government order shutdown. And it's like, no. If you had trouble getting supplies, and the example I used years ago was, or used during this pandemic was, remember that there was a short time where we couldn't get sriracha sauce, right? Sriracha sauce was in low demand because there'd been a crop failure, you know, from the places where, the best known sriracha sauce, where the ones they use, the peppers they use. So there just weren't enough peppers and they didn't want to go use alternatives. Had nothing to do with COVID. It had everything to do with just a standard crop failure, bad weather, et cetera, in the areas, damages, et cetera. Yeah, the mere fact you had trouble getting sriracha was not caused by COVID-19. It was caused by the farmers not being able to produce enough chilies. You wouldn't get there. You've got to show me the exact order. Don't just say everybody knows, which actually they tried to say here. Where everybody knows this is no. This is called a court of law. You produce the chain of proof. You actually chain this all together to show how all the details work. We don't just sit here and everybody knows. Nope, I'm sorry. Now, it's like maybe I'm an idiot, and calling your judge an idiot is probably not good when the judge says, but I don't know that. Generally, I'm not going to go look it up. I'm not going to go search for it. That's your job, plaintiff. Prove your case. Don't just tell me your case is, quote, obvious, and I don't need to submit any proof. It's not that obvious. Okay. So let's read our final visual summary. On the left side, we're looking at the definition of what is a partial suspension. How do we define that in this case? What's a stoppage versus a shutdown? All those issues. You know, what we have here is being less efficient is not going to be considered a suspension, and revenue is not, in the view of this court, a metric that can be used for defining a partial suspension. And then the due to causation standard. Again, the Court of Federal Claims is adopting a stricter standard than merely due to, I should say, but for. So we need to be aware of that, right? You need to find a specific government order, right? We got to tie that in here. Got to tie the orders to the quarters and what exactly and why it impacts your business. I've got to find a whole chain of causation here that gets to you basically shutting down part of the business, stopping part of the business. We have that. We basically have, both it must be but for and proximate cause must be shown. And supply chain failures just generically is not going to work. Sorry, not working. That's there. So this concludes our review this week of the developments for the week of June the 29th. So we have a lot of material covered today. We had the de novo review and nominee rules in Steelman, the dual pathway recovery and pleading standards for the ERC credit in plastic film given to the government, corporate formalities and civil fraud penalties in HE, collection due process hearings and, reasonable collection potential calculations in TOOK, non-delegable circular 230 duties under the new OPR AI guidelines, and the strict dual causation standards we had in Sundancer Pool. Hopefully this is useful to you in what your clients are doing. Again, as always, my email address is on the slide at zollars@commercialtaxdevelopments.com. You can contact me there. I also do monitor the Connect groups for Arizona, New Jersey, these CPA societies for Arizona, New Jersey, Illinois, Idaho, Minnesota, Washington. So keep that up. And we will be coming back, hopefully next week, looking at some more developments. I already know I got more ERC cases. Isn't this wonderful? Yeah. Yeah, ERC cases are now going to court and hitting the points where courts are ruling on at least motions to dismiss. So we are starting to get a much clearer view of what exactly the courts are doing. Now, we won't know for sure until we see something go to the appellate level, whether or not, the appellate courts are going to do this, because we know we have different ideas. But aside from the Eastern District of Washington case, so far, it's not looked good. For partial suspension cases appear to have a higher bar than many claims assumed they would have. Again, Eastern District of Washington, that case is, for the moment, and it may all change next week because we get a whole bunch more of these. Right now, that one appears to be the outlier. Just be aware of that for the moment. Otherwise, we're going to see you back here next week for more current federal tax developments.